So today we're going to be talking about sealing your criminal case in DC. We're going to go straight to it. So why should you seal your criminal record? Well, it's an informational world, and that means that all the information is on the internet now, and people make judgments based on what they see on the internet and what they learn about you on the internet. Furthermore, you have employment, and employment's important, and if you have a criminal record, it could hamper you getting employment. Housing, it's pretty obvious in housing when you're trying to rent or buy a house. And career advancement, trying to go up the ladder. If there's two people competing for the same job and you have that criminal record, it could cause your delayed career advancement. And finally, what comes along with everything is discrimination. So while being discriminated for just for having a criminal record, someone thinking less of you because you have a criminal record, it may have happened a long time ago, maybe when you were younger or whatever, and you will be discriminated against because you have that criminal record. So when you're deciding whether you should seal a record, first you have to make a decision of whether it's a misdemeanor or a felony. Now, a felony or a misdemeanor is anything that carries less than a year, and a felony is anything that carries greater than a year. That's kind of based on common law, DC's law. But you should know that before applying, because most of what I'm about to talk about today is referencing misdemeanors, because in the District of Columbia, felonies are not technically, you're not able to seal them except for one. And the one that's allowed to be sealed is failure to appear in court, also known as Bail Reform Act violation. But we'll talk about that shortly. So adult criminal records in DC, there are several ways to seal a record. So the first one is under actual innocence. And that means that if you're actually innocent of the crime, and you could pursue to seal the case under actual innocence. You also have something they call the interest of justice. Now, interest of justice means that it is in the best interest to have the record sealed, and there's a variety of factors that you're asking the court to look at for why the record should be sealed. The next one is mistaken identity. We're not going to get too much into that one, but it kind of speaks for itself. It's very similar to actual innocence. And then we have decriminalized matters. And there's one that I didn't list here as fugitives. We're not going to go into that because that's a very rare thing for most people to have for a DC record. So we're really going to just focus on actual innocence and interest of justice. Like I said, the mistaken identity and the decriminalized matters, we don't see them as much. So let's start with actual innocence. Now, the actual innocence, basically that motion, and when I say motion, that means that you're making a request to the court to do something. And in this case, you're making a motion to seal your criminal case. And the first way you're doing it under, one way of doing it is under actual innocence, and it's under DC Code 16802. And it says that motion can be filed anytime after the case is terminated. So a lot of times what we see this in is that your first time in court, the case is what they call no papered or dismissed or nollied by the government. You can then file that motion to seal if you were actually innocent of the charges. But remember, you have to prove that the offense did not occur or that you did not commit the crime. And when I say you have to prove it, normally in a criminal case, the government's required to prove that. But when you're pursuing to go on actual innocence, you are the one who has to prove that you're actually innocent of those charges. Now, there are some requirements, and this is why it gets a little technical. If you file before 4 years, you have to prove by preponderance of the evidence that you are innocent of the charges. If you file after 4 years, you have to prove by clear and convincing. Now, what does all that mean? Well, and I'll just note that acquittal, because some people say, well, what if I went to trial and I was found not guilty? That also is not actual innocence. So what do I mean by that? So if you look at this diagram right here, and I'm going to break it into three parts. We have preponderance of the evidence, we have clear and convincing, and we have reasonable doubt. It's not asking for reasonable doubt. Reasonable doubt is the higher standard of proof in a court. And that's generally on a criminal case, you go to trial, the government has to prove, or the prosecutor has to prove beyond a reasonable doubt that you did it. But these other two standards are not, it's not the same proof. So preponderance of the evidence is kind of a civil standard and basically saying that there's a greater chance than not that you're actually innocent. So you can see that that's less to prove. So you'd only have to prove by 51, maybe 51% that you are actually innocent. But to prove clear and convincing, now you're getting, and I hate to use numbers like this, but now you're getting a little higher, and so maybe the percentage is maybe 75% that you have to prove that you're actually innocent. But just to kind of show you the breakdown on that graph on how it works. If your motion to seal is granted under actual innocence, it's as if the arrest never occurred. So proven actual innocence. So how do you do that? So when the motion is filed, you generally submit an affidavit, sworn statement of facts as to what actually happened, of why you were actually arrested. You can also submit witnesses' statements if you have them. It's best to have, if you have statements of other people that can say what happened on the scene. And any other evidence that you deem important. You can submit exhibits with your motion saying, hey, judge, I'm asking you to look at this because this proves that I was actually innocent of the charges. And so that's actual innocence. Now we're going to talk a little bit about interest of justice. Interest of justice is the other motion that can be filed to seal your criminal case in DC. Now, in order to, on the interest of justice motion, unlike the actual innocence, you remember, could be filed at any time. But on the interest of justice, you must meet the waiting periods. And I know you're about to ask me the next question is, what are the waiting periods? Well, the waiting periods vary based on the charge. And it's a little too much for me to go into every single charge, but some charges require you to wait 2 years, some require you to wait 3, some require you to wait 4. So it depends on the charge and at what point the case was terminated. So, like I said, the waiting periods vary depending upon when the prosecution was terminated. And then the waiting period begins when the prosecution was terminated. In other words, if the 2 year that you had to wait, it's not from the date of the arrest, it's from the date the case was dismissed. So you'd have to wait until the case is dismissed before you can file a motion in the interest of justice to seal. And at the time that you file this motion, you must seek to seal all eligible cases. You can't seal one case and not seal another. You have to seal all the cases at the same time. Now, 2 types of misdemeanors for sealing. There are eligible misdemeanors, and those are your typical, general of the mill, if there is such a thing, misdemeanors. You have unlawful entry, you have simple assault, assault on a police officer, possession of drugs, threats, theft, attempted misdemeanor charges. There's actually too many for me to list. I mean, you'd have to go through the entire criminal code to figure out all the misdemeanors that they have. But the distinction that I want you to make here is that there's eligible misdemeanors and then there's ineligible misdemeanors. And we're going to go into that. Now I have another video, and I'm going to have a link at the bottom here on explaining which misdemeanors are ineligible, because that list is not too detailed. It's maybe 23 misdemeanors. So ineligible misdemeanors, as well as no felonies except for failure to appear in court. So felony, you're not able to seal any felonies except for failure to appear in court, also known as Bail Reform Act violation. So ineligible misdemeanors, just a sample of a few of them: DUI, domestic violence cases, misdemeanor sex offenses cases, credit card. And then again, at the bottom of this video, you should see our YouTube on ineligible misdemeanors, and it gives you the whole list as well. So eligible misdemeanors in filing your motion to seal. Now, most of them you have to wait 2 years, and that definitely, if the case was terminated, in other words, if there was no papered at the arraignment, you still have to wait 2 years from the date of that dismissal. Again, unlike the actual innocence, where you can file it immediately after the dismissal. You can't have any misdemeanor convictions within the last 5 years, no felony convictions within the last 10 years, no pending cases, and you have to have met all the waiting periods. Eligible misdemeanor convictions, in other words, if you were convicted of a misdemeanor, can you seal that case? Yes. So some of those eligible misdemeanors that you just saw on the previous screen, like simple assault, unlawful entry, threats, those are eligible to seal even if you lost at trial and you were convicted. You'd have to wait 8 years since the sentence was completed. And again, you can never been convicted of an ineligible misdemeanor or felony, except for the BRA, of course, and no convictions except minor traffic offenses during that time period. And minor traffic offenses is disorderly conduct and any offense that is punishable by a fine only. And you can't have no pending cases except for the minor offenses. And again, all waiting periods must be met. Now, what does the judge decide when the judge is deciding in the interest of justice motions? So the interest of justice motions, the court looks at a variety of factors, and basically the community's interests in retaining or making that record public. So that's one of the things the court's going to look at. It's also going to look at the nature and circumstances of the actual offense. It's going to look at your role in the case and what your role was in the weight against the what the weight of the evidence was against you at the time, and the history of characteristics, including all these: character, physical and mental condition, employment history, prior and subsequent conduct, history relating to drug and alcohol abuse and treatment. So, in a nutshell, when you're filing that motion in the interest of justice and you're saying to the judge, Judge, when I was arrested for, let's just say, simple assault, you got into a fight because you had gotten into a bar fight and you had been drinking during that period of time, something happened and caused you to become an alcoholic and you start drinking. But since then, since that case occurred, you got your life together, you went to AA, you stopped drinking, and you got your life together, showing that you had improved your career and you start doing things to better your life. That's what you're putting into that motion. So that's what you're saying to the judge. Hey, judge, this is what happened back here. That's changed since then. I'm now a different person, and I'm asking that this record not be held against me. So what does it mean if your case is sealed in the interest of justice? So the reason why this is broken down differently is because interest of justice motions, if you are granted your case is sealed in the interest of justice, the record is still accessible to certain parts of the public. And any court can still access that record. It's still not accessible to the public. Any federal, state, or local prosecutor, any law enforcement agency, any licensing agency, daycare center, or child protection agency facility. So they can still access those records. Now, granted, again, it's hidden from the public. That means the public does not have access to that record. So, and then finally, employment or judicial officer. So they have access to those records. So when you're granted a motion to seal under the interest of justice, you will get an order from the court saying, hey, you are now allowed to answer the question. And the question before you is, have you been convicted or have you been arrested of the charge? You can say, no, I've never been arrested without committing perjury or misrepresenting yourself. And that's exactly what that order says. Exactly what you see on the screen right there is exactly what the order will say, except to these things. That means that if you're asked on a questionnaire by one of these organizations, you would have to say, yes, I was arrested. So it spells out these organizations that you would still have to list. And one of the other important ones is jury duty, because that would, if the judge asked you at the bench, have you ever been arrested? Well, we don't want bias against the person who's on trial. So you would, in secret, you say to the judge in private, yes, I was arrested. So that's what it means to have your record sealed in the interest of justice. Now, how do you get the records? And this is another important issue, is that how do you get the records to determine your eligibility? The first way is you go to the fourth floor DC Superior Court Courthouse, 500 Indiana Avenue, and you can go up to the fourth floor and you can ask the clerk, give them your name, and ask them to print out any records that they may have on you. That's one way. You can also go to the Metropolitan Police Department, or you can email them, and I think the email here, you can see the email right there, and you can certify your records from the Metropolitan Police Department as well. So that's one way of getting the records to determine your eligibility and to see if you're eligible, is to get those records. And you want to do that before you file your motion. What's the process after you file the motion? Well, the court will give the prosecutor between 60 to 90 days to respond to your motion. So before anything happens, there will be another court order that comes out that the court's going to say, prosecutor, you have 60 or you have 90 days to respond to this motion. Now, the prosecutor has two choices. The prosecutor can concede your motion or he can oppose it. If the prosecutor opposes your motion, the court can deny your motion without a hearing, grant your motion with a hearing, or schedule a hearing. So generally, on a motion to seal under actual innocence, the prosecutor may oppose it and submit an affidavit from the cops saying that this is what the cops swore out, this is what the cops saw. And the judge may say, well, you haven't proven your case on a preponderance of the evidence, and then dismiss the case. Or, which is more rare, that the judge could actually schedule a hearing. But most cases are decided on their paper. And just from doing this a long time, I think that most judges generally try to go in favor of the movement, meaning you, and they try to rule mostly in your favor, because if you've produced enough and you show enough that the reason why this case should be sealed, most judges are willing to grant that, even opposing the prosecutor. And most of the time, the prosecutor, if they think this is a weak case or that they can't meet their burden, they just go ahead and concede. Oh, and I say this, that it's a very slow process, and in fact, some of these cases can take up to a year for them to seal. That's longer than generally, but it can take that long because sometimes the prosecutor wants more time, and the court gives them more time, so it can take a long time for this to happen. If the judge grants your motion in interest of justice, remember, you can now answer the question of have you been arrested or convicted. You can say no without committing perjury. And the court will order several agencies to take steps necessary to seal the record from the public. Now, like I said, under actual innocence, it's a little different because they're not able to get to the public records at all. If you file under actual innocence and it's granted, the clerk will be required by the court to purge all records. Now, they are allowed to keep, the clerk can keep a separate file for these records, but for the most part, all records are sealed and all records are purged. So it's a little bit of a different process if you get interest of justice motion, because everything is purged and it doesn't have that public option where certain entities can get to your records, such as the daycare and things like that. Because if it's granted on actual innocence, everything is purged, and it's actually can be a little bit better of a motion because actually everything is purged. But either way, under either option, your record would be sealed. So if your record is sealed, that means the public can't get to it, and it's the way that you can answer that question. And you know the question on the application that says, have you been, I don't think it generally says arrested, it generally says convicted. But you can say, no, I've never been convicted, and you can say that without committing perjury or misrepresenting yourself under either option. So as I stated earlier, there are the other two, which is decriminalization of crimes and mistaken identity, but those are a little rarer, and that didn't go into that in this video. But if you have any other questions, you can always reach out to me. My name is Mark Rollins. I'm an attorney here in Washington, D.C., and I practice at Rollins & Chan Law Firm. I appreciate you watching the video, and as always, subscribe to our channel. Thank you.